One simple question. If I ask you to define India in a legal sense, what will be your answer? Hey guys, welcome to my legal classes. This is Ganesh Poojary, and in the series of Civil Procedure Code, we were discussing part 1, which is all about suits in general, covered between section 9 to 35A. In this series, today I am going to discuss about foreign judgments. When I say foreign judgments, first we need to understand what is foreign court and foreign judgment, which are defined under section 2 clause 5 and 2 clause 6, and then we are getting into two important sections, that is section 13 and 14 on foreign judgments. While discussing so much about foreign judgments, we need to understand what is India and what is foreign. So I have some bonus elements on this particular session. Not taking much of your time, let's get into the first slide. Let us start the discussion with the definitions which are available under section 2 clause 5 and clause 6. Section 2 clause 5 defines what is a foreign court. It says foreign court means a court situated outside India and not established or continued by the authority of the central government. 1. It is situated outside India. 2. It may be situated outside India but not continued or established by the central government of India. Both of those types of courts are foreign courts. Coming to section 2 clause 6 discusses about what is foreign judgment. It says foreign judgment means the judgment of a foreign court. Now clause 5 defines what is foreign court, and clause 6 says whatever judgment is given by such foreign court is a foreign judgment. Now here foreign is very clearly defined, which is outside India. Now before we say outside India, we need to understand what is India. To an answer for this question, that is what is India or what is Bharat, we have to refer part 1 of Indian Constitution, which has 4 articles starting from article 1 to 4. And to understand what is India, you need to read article 1 of Indian Constitution, which discusses about name and territory of the Union. It says India, that is Bharat, shall be union of states. That means there are many states and this country is union of states, and the states and the territories thereof shall be specified in the first schedule. So to see which are the states, we have to refer first schedule. There is a schedule available where all the names of the states and territories is mentioned. And thirdly, the territory of India shall comprise, what is that? The territories of the states, the union territories specified in the first schedule. If you refer the first schedule, you will see the name of all the states of India and union territories and such other territories as may be acquired. So India is not limited. Over a period of time, if we are acquiring anything, that will also become the part in the first schedule and that becomes part of India. That is what we need to answer if someone asks you what is India. Coming to section 13, it discusses about when foreign judgment not conclusive. This is a beautiful section where in the first half it discusses about the judgments which are conclusive when given by foreign court. Saying so, the second part, which is very important, discusses about those circumstances when a foreign judgment is not conclusive or the exceptions for this particular section. Now the section is in my next slide, but before going there, I have two beautiful charts to define section 13 easily. In the first part, it says a foreign judgment should be conclusive when it is directly adjudicated, when it is between the same parties and for the same title. Now we have already understood this concept under section 13 when we discussed res judicata. Here the matter is directly and substantially the same, parties are the same, title is the same, heard by a competent court and decided by such competent court, and after that there is either no appeal lies or the appeal is decided or the appeal period is expired. In that cases, we cannot bring the suit again as under the concept of res judicata, and the same applies for the foreign judgment also. Once the foreign judgment is given, it should be considered that such judgment is conclusive. That is all about the first part of section 13. But then comes 6 important exceptions. If you see the title of section 13, it says when foreign judgment not conclusive. Here are the 6 very important exceptions where the foreign judgment is not conclusive. And I have discussed all such exceptions with details and with sufficient notes so that you have sufficient ingredients to answer the questions related to section 13 and 14. Let's get into the 6 important exceptions. The first exception is the foreign judgment is not conclusive when it is given by a court which doesn't have jurisdiction, or the incompetent jurisdiction is the first exclusion for the validity of foreign judgment. What is competent jurisdiction? We have already understood while discussing section 9 of CPC, there are 4 different types of jurisdiction. The first one is pecuniary jurisdiction, the second one is subject matter jurisdiction, the third one is territorial jurisdiction, the fourth one original and appellate jurisdiction. Now, if the court doesn't have competent jurisdiction to hear the case, and if it has heard and given a judgment, such judgment is not conclusive. That is the first exception. The second exception when the foreign judgments are not conclusive is when such judgments are against the merit of the case. Now, what is merit of the case? It differs from civil to criminal. What happens in civil case when there is a case between A and B? If A gives more evidence and if A proves more fact, in that case A's case becomes very strong and B loses the case. Like for example, if A gives 51% or more evidence, his case becomes strong and he wins the case. But the concept of merit of the case is completely different when it comes to criminal cases. Here, only after beyond reasonable doubts in a proceeding an accused get convicted, otherwise he will be acquitted. And when we are discussing the Indian Evidence Act, Chapter 7, the burden of proof, which is covered between section 101 to 114A, it discusses all about who has the burden to prove. All of that is discussed in that particular law, but for now you need to remember that the foreign judgments are not conclusive when they are against the merit of the case. That is the second exceptions. Here, one very important aspect you should always remember is, just for the sake of making it clear, I am also bringing in criminal case references, but it is not that we are studying criminal cases here. We are focusing on the Civil Procedure Code and our answer should be aligned to that. But just to give concept clarity, I have also brought criminal case. Now, for example, when we are discussing burden of proof, section 105 of Indian Evidence Act doesn't apply to CPC. These are the things we should know. And to make concept clear, I am bringing all of these aspects and you need to remember that. The third exception is when a foreign judgment has incorrect view of international law or not respecting Indian law. When I say international law, it may be public international law or private international law. And to understand these concepts, you need to visit my playlist on public international law, where I have defined what is public international law, what are private international laws, and what are the differences between these two. I think you need to invest some time on there. And with that, I am moving to the fourth one, which discusses about when such judgments are against natural justice. When it comes to principle of natural justice, we need to know two important doctrines. That is, nemo debet esse judex no propria causa, which means doctrine of bias, and then we have audi altrum partem, that means rule of fair hearing. When we discussed in my playlist administrative law on the doctrine of bias, I very clearly told you that there are three different types of bias: the personal bias, pecuniary bias, and subject matter bias. And again, under personal bias, we have personal friendship, personal enmity, and the judge-witness relationship. All of these are discussed in my administrative law playlist. You can visit my playlist for Principle of Natural Justice, where again I discussed these two doctrines in independent videos. So you can get more details in that particular videos. With that, I am moving to the fifth exception. The foreign judgments are not conclusive if the judgment obtained by fraud is the fifth exclusion. Now, the beauty of law is we cannot read one single law with that particular law. We have to understand a law as a combination of many laws. Now, what is fraud? To understand fraud, you need to go to my playlist on Contract Law 1, where I have made an independent video on section 17 of Indian Contract Act, where fraud is very clearly defined. When somebody deceives another party, or when there is concealment of fact, or when there are false promises, or when there are misleading facts, all of them are coming under fraud. And if a judgment is taken by a foreign court by such kind of fraud, in that case the judgment given by such foreign court is not conclusive. That is all about the fifth exception. Coming to the last exception, the foreign judgment is not conclusive when the claim is breach of Indian law. Like for example, maybe gambling is legal in XYZ country and the case is heard there, and there the judgment has came, and if the same is appealed in Indian court, in that case the judgment given by XYZ country or such foreign court is not valid, because in India gambling is not legal. It is breach of Indian law, so such judgment given by foreign court is not conclusive. That's all about the exceptions under section 13. Please take the screenshot for the purpose of section 13 legal provision. I have discussed every single word of this particular section in detail in my previous slide. So not investing any further time, please take screenshot. Coming to the case laws, the very important case law that you can refer here is MS International Woolen Mills versus MS Standard Wool Limited. Here the court said that the foreign judgments, when given not on the basis of merits, the same cannot be executed in India. So giving judgment on the basis of the merits by a foreign court is one of the essential requirement, else it cannot be executed in India, what held in this particular case. And here the burden of proof concept also discussed in detail, and it was held that the appellant has the burden to prove that the case was not decided on the basis of the merits. That's what held in this case. Another case that you can refer here is Raja of Faridakot versus Guru Dayal Singh. This case law, the details have given. This is a pre-independent case. If you want to refer one more case, you can refer this. With that, I am moving to section 14. Section 14 discusses about presumption as to foreign judgments. It says the court shall presume upon the production of any document purporting to be a certified copy of a foreign judgment that such judgment was pronounced by a court of competent jurisdiction unless the contrary appears on the record. That means when a foreign judgment is produced in front of Indian court in the form of a document, and if the party says it is the certified copy of such foreign judgment and such foreign judgment is given by the competent jurisdiction of such foreign court, in that case the court shall presume that such document is good document or a valid document or a valid evidence unless the contrary is proved. Now here there is one important exception which says such presumption may be displaced by proving want of jurisdiction. That is one exception available. Now while reading this particular part of section 14, we need to remember section 76, 77 and 86 of Indian Evidence Act. Section 76 of Indian Evidence Act discusses about certified copies of public documents. 77 discusses about proof of documents by production of certified copies, and 86 has words like certified copy of a foreign judgment. Now all of these sections need to be read together, and only when such document suffices all the requirement under the Indian Evidence Act, that documents become a valid document and valid evidence. So that is the importance, and this particular aspect is also discussed under Y. Narasimha Rao versus Y. Venkata Lakshmi case law. Now that is what we can refer. So all you need to remember when we are applying section 14 of the CPC, we need to read that along with section 76, 77 and 86 of Indian Evidence Act.
Giraffes have long neck. Elephants have big trunk. Rabbits can run really fast. Monkeys can jump from tree to tree. That's their abilities. Papa, what's human abilities?
We human can communicate really good. It is not that animals cannot communicate, but they cannot communicate as good as humans because we have language. Only thing we have to ensure is we have to raise our voice when bad is happening, and we have to praise those people who are doing good.
With that, I'm concluding this session.